My name is Clint Negley. I'm with UC Davis Innovation Access, the Tech Transfer Office for the UC Davis campus. This is the fifth in a series of presentations with a series entitled Intellectual Property and Technology Transfer. This particular presentation is entitled, What is the Process for Filing and Obtaining a Patent? The process we're talking about is a multi-step process. It typically begins with receipt of a write-up of the invention. Receipt of an invention disclosure. At UC Davis, we call it a record of invention. We call it the ROI with affection. At UC Davis, submission of the ROI by the researcher to the Tech Transfer Office satisfies the duty under UC policy to disclose potentially patentable inventions. That initiates the process. The Tech Transfer Office, our office, moves ahead with the decision process. What should we do with this invention? Should we file a patent application on it or not? That decision is important for many reasons. The stakes are potentially high, but the workload is potentially high. The cost is potentially high. So it's important that the decision be done carefully and analytically. The decision is made based on two primary considerations. First is, what is the patentability of the invention? And second, what is its marketability? Both are important. Either without the other would not be a sufficient basis to proceed with a patent filing. So patentability, which you've heard about previously in this series, is the likely scope of patent claims that would issue in a patent based on the given invention. Marketability is the licensability of that patent with those claims. Patentability alone is not enough to warrant a patent filing. If no one's going to take up a license, then there's no reason for the university to spend the time and the money. We don't commercialize products directly. We only commercialize through licensees. Absent a licensee, there's no point in proceeding. If we have great marketability for a given invention, but we don't have reasonable scope of patent claims, that's not a sufficient basis to proceed with a patent filing. No one will take a license to a patent that has extremely narrow claims. So this is the basis of the decision. It's the assessment process that the Tech Transfer Office goes through before proceeding further with patent filings. If the decision is made to proceed with a patent filing, there are two separate tracks, two separate timelines for the patent filing based upon whether the filing is in the U.S. or whether it's made abroad. And I'll address each of these separately, even though they're parallel and concurrent processes. So in the U.S., if a decision is made to file for a U.S. patent application, which would give rights in the U.S. but not elsewhere, as you've heard previously, rights to prevent others from making, using, and selling the invention, then the first step typically is to file an initial patent application, which is called a provisional patent application. A provisional patent application is a placeholder. It is nothing more than that. It is a 12-month placeholder. It provides assurance that that filing date will be the effective filing date for this patent application. Filing dates are extremely important. If someone else publishes later on the same invention or something related, then this filing date allows the applicant to overcome that other publication. But the Patent Office does not pick up this patent application at all until the 12-month mark. So the 12-month mark is the next decision, whether to file it again in the form of what's called a non-provisional patent application. For the University Tech Transfer Office, the decision of whether or not to file a non-provisional typically turns on whether there has been interest expressed by companies in obtaining a license, or whether a company has already entered into a license agreement with the university. If so, then we would certainly proceed, and typically The licensee would pay the patent costs. If there's no licensee on board, then it's a decision as to whether the university is going to go further out of pocket at that point in time to extend the rights. And if so, the non-provisional will not only extend the rights in the process, but it will initiate the main part of the process, which will then go on for several years. Filing the non-provisional is something that activates the patent office. At that point, for the first time, they pick up the patent application. They review it, not immediately. Often it takes a year, sometimes longer, but they pick it up, they review it, and routinely they send an official communication back with a host of reasons why this invention is not patentable, why patent protection should not be sought. And that begins the real communication process with the patent office. This is where the patent person's skills come into play. The applicant, through the patent representative, can then argue all the reasons why the invention is patentable, why the patent office is wrong, why this is an important invention, why the advantages are unexpected. That process can continue for 2 or more years. There can be appeals, there can be refilings, but if all goes well, it will result in issuance of a patent, perhaps as long as 4 years from the original filing. Best case may be 2.5 years. And there's an expense. It can easily cost $20,000 to go through that process. Partly patent office fees, partly fees charged by the patent lawyers that are on the outside and representing the university in the process. If things do not go well, then no patent will result. Typically, a patent can be obtained, and the real question becomes what will be the scope of the claims that the patent office is willing to grant. That's the U.S. process. There's a parallel foreign process, which has steps that kick in at the 12-month mark and continue over a longer period of time. So if foreign rights are to be pursued, in particular if a licensee is interested in pursuing patent rights abroad, then a different type of patent application is filed at the 12-month mark. It's an international filing. It's typically referred to as a PCT patent application, which stands for Patent Cooperation Treaty. There is a treaty with 100 countries or more signed on, all the major countries of the world, and a single filing at the 12-month mark serves as an additional placeholder for another 18 months. Patent rights are in place and patent applications are pending, in effect, for all of those countries around the world. This is really useful for the university because if we need more time to find a licensee company, that gives us up to a total of 30 months to find someone who will support the costs of the patent and signed up for a license agreement with the university. At the 30-month mark, the so-called national stage mark, it's time to enter individual countries, country by country around the world. For any country which is entered, there's the opportunity to begin patent prosecution and the hope of obtaining an issued patent in that country. For any country in which national stage is not entered, then there will not be the possibility of getting patent rights in that country. So it's a complex process around the world, this single invention covered by many patent applications, prosecuted through representatives in countries around the world. Issuance will result if all goes well and if the money is there to underwrite it. It can easily take 4 to 6 years or more. Translation costs are involved. There are special proceedings involved where the patent applications can be contested. It can be a very expensive process, $100,000 or more, depending on how many countries are entered. So for the university to go this route, this national stage route in foreign countries, it's really important to have a company signed up as licensee and in order to cover the costs of the patent filings in all these countries. In summary, the process for filing and obtaining patents is partly in the U.S. and it's partly abroad. In each case, there are many steps. There's considerable time involved and considerable expense. If all goes well, a given invention can lead to important patent protection around the world. Thank you.